quickly there. All right, I don't know if this is working. Nothing's on, nothing's there. All right. All right. We are good to go. Welcome, everybody. I think we've got this going the right way. We've got a whopping 2 viewers. So one of them is Mario in this room, the other might be me. So we're going to wait until people start to pop in here. Oh, there we go. That number's jumping up now. All right, everybody, thank you so much for joining on this the Lunch and Learn webinar for you guys, obviously free of charge since you're all here and you didn't pay any money. The purpose of today's webinar is going to be focusing on proofs of loss and estoppel, what that really means in the insurance industry, how you can ultimately use the words that the carrier tells you in the field against them. One of the biggest problems I hear constantly from adjusters when I go to events and get phone calls is, well, they told me that I was going to be covered for X, Y, and Z thing, and ultimately they go back to their office and they don't cover it. So in those situations, what can you do to hold them to their word? Today's webinar will focus not just on the law, but on actual practice for you guys, what policy language is out there, how to use this stuff against them, and really hold them accountable for everything they're doing. The other big focus on this, other than the estoppel, will be the proof of loss issues. The proof of loss stuff will come up in both how to fill out a proper proof of loss, what you can use a proof of loss for, and what to do when the carrier is not responding or not responding appropriately to these proofs of loss. Some people are still joining in, so I'm going to hold off on a few more minutes while people are getting in here. But one of the big things I want everyone to remember is there is a live chat. It is being monitored right there by my partner Mario Barnaby. He will be able to upload questions to the screen as they come up, so feel free to use that live chat. While we're in this little time beforehand, I want to confirm, can everybody hear me okay? Any issues? If anybody could type into the chat that things sound okay, let me know. We've been working with this updated camera. Last time we did this, there were some focus issues. I think I've got that worked out because I turned off the autofocus. I don't know if this is going to make any difference, but figured I'd give it a shot. But want to make sure that everyone can hear me as well. Otherwise, I'm just talking to nobody. Well, Mario, and he already knows most of this. Appreciate it, Howard. Jason, got it. All loud and clear, so we are good to go. We've got a really great turnout today. There was a ton of response to the initial rollout of this. A ton of people signed up. There was like 180 some people that are interested in this. As always, these are going to be available online afterwards. So if you have to jump out early, you can come back to our website and take a look at the live video and do it that way as well. Works out just as good for everybody who's out there. This resource is meant to be used by you guys. I mean this, and I say it every time. I don't know if all of you believe this yet or not, but I really do mean it. I don't want you to have to come to me. The purpose of these Lunch and Learn webinars is so that you can do things in the field so that you don't have to call an attorney, that you do get coverage and it never has to cross my desk. That's the goal. Insurance companies are always going to be unreasonable. When they are, I have to step in, and that's fine. But if we can work as an entire industry to get an understanding to fight this monolith of a insurance industry with endless pockets of money, we can do it unified together. We can get this information out there and make it better for everybody involved. All right, so let's jump into this. Let's make sure my clicker is working, and it is. Here's some contact information, just to remind anybody who doesn't know. My name is Tony DiUlio. I'm a partner at Wheeler, DiUlio, and Barnaby. I practice almost entirely in this field of property damage litigation. All day, every day, I review insurance company policies. I see damage to loss. I look at estimates. There's little that I have not seen at this point, although I still find myself getting surprised every once in a while by how egregious these carriers are being. If you guys have any questions, email address, feel free, shoot me an email anytime, day or night, doesn't matter. This is the office number. You can feel free to give me a call anytime you need. If I'm not available, there's a good chance that some other attorney here is. We pride ourselves in focusing our attorneys on property damage litigation. So just because I'm not here doesn't mean someone like Mario, my partner, Mr. Barnaby, can't answer these questions as well. But feel free to give me a call anytime. So let's jump in. I told you today is going to be about estoppel and proofs of loss. So let's first focus on estoppel because this comes up all the time. I'll get a call and someone will tell me, Tony, the insurance company told me they were going to cover this in the field. 2 days later, I get a denial letter saying it's not covered. What can I do in that situation? Is that waiver? Is that estoppel? In that situation, there's little you're going to be able to do. Estoppel, it's an affirmative defense alleging good faith reliance on a misleading representation and an injury or detrimental change in position resulting from that reliance. Well, that's super legalese talk. What the heck does that mean? What it means in layman's terms is someone said something, you relied on it, and that reliance caused you some type of harm. That harm part is the key that everything we're going to look at focuses on. And that's why in the general situation of carrier says one thing, then writes a letter of another, there's no actual harm there. Here's the trick. When you get that statement, when you get that comment in the field from the carrier, you send them an email immediately afterwards. As soon as you get in the car, you can type it and say, hey, just to confirm, this is what you just said in the field. Great. Now you've documented what it says. And now you go to your homeowner and say, they've made this comment. Are you willing to sign a contract with a contractor? You don't have to start the work yet, but are you willing to sign a contract with a contractor so that you're locked in to doing the work that the carrier has said? It's covered. If you get that, if you can get something being done, an affirmative action that will cause the property owner harm if the carrier backs off of their word, now it's estoppel. Now the carrier has to be locked in because what the courts have said and what we're going to look at is, well, wait, hold on a second, insurance company. You told them X. They believed you. And they did something affirmatively. They signed a contract with a contractor, for example, or they had remediation work done to the property. If that's the case, then we need to make sure that you're responsible for making those statements. And these insurance companies will ultimately be held accountable for that. This happens a lot when a homeowner will actually call a claim in themselves. So it happens really often. They've got a water loss at the property. The insurance company says you need to mitigate the damages. And the homeowner will often say, well, okay, I can do that. I just want to make sure that it's covered. And they'll say, yeah, that part's covered under your policy. Go ahead. I can't tell you the number of water loss cases I've got where the insurance company will send out the recommended remediation company and ultimately deny the claim saying, oh, you know, it was a long-term leak or some other factor. And their response is, well, hold on a second. You just tore out my house with this remediation company. How can you do that? They can't. That's detrimental reliance. That's estoppel. And if you get to that estoppel, you can get your coverage for what they say in the field. So, quick recap on this. If they give you something in the field that says something's going to be covered, there's an agreed upon scope, covered under the policy, whatever the case may be, send an email, put it in writing that they have said this. Then get your client to do something that proves they've relied on it and causes them damage if the carrier doesn't stand by their word. Signing a contract is enough. Doesn't have to mean the work is actually done. If you guys have questions about that as we're going through this, please let me know. I want to reiterate this, and I'm going to move through these next slides a little quickly because they're super boring and they're just law. Our firm practices in a lot of states. We've got counsel in a lot of states. I want to focus on some of the ones that we practice in the most. So we're going to see Pennsylvania, New Jersey, Maryland, Virginia. I've also got attorneys in North Carolina, New York, down in Florida. We're working all over the place. I've actually started, I'm going to be pro-hawking into Oklahoma in a couple of weeks. So really, if you've got an issue anywhere, give me a call. I'm going to do everything I can to help. Taking a look at Pennsylvania law. I always feel like a weatherman when I'm doing this, like talking to the screen. In Pennsylvania, all of these states, by the way, and all the law is going to be very similar to what I said, but I want you to see it in case you need it. We've got an inducement, that's the statement, that causes one to believe the existence of certain facts. Yes, you're covered for this. Great, that's an inducement. Justifiable reliance on that inducement. I believe you because you're my insurance company. I'm going to trust that. And the prejudice. Prejudice is just another form of damages. They have been prejudiced because they believed it and now have a contract or have work done on their property. There must be such conduct on the part of the insurer as would, if the insurer were not estopped, operate as fraud, on some party who has taken or neglected to take some action to his own prejudice in reliance thereon. Super legalese says the same thing. It's just another case in Pennsylvania that stands by it. With any of these cases, if you guys need the cites for them, please let me know. I'm happy to provide it. You do want to be careful. You aren't attorneys. At least I don't think there's any attorneys on here. Maybe you are. Great. But if you're not, don't practice law. You can cite to case law. You can't interpret it. So you can put in these cites. You just can't interpret what it means. So PA, great. We have the same standard. New Jersey, Griggs v. Bertram. Under certain circumstances, an insurance carrier may be stopped from asserting the applicability of insurance to a particular claim against its insured, despite a clear contractual provision excluding the claim from the coverage of the policy. Again, in layman's terms, all that means is just because there is an exclusion that clearly would allow them to deny this loss, if they've done something that somehow makes that not the case, if they've said something, stopped the property owner from this loss, then they've got the coverage. Even if an insurer which does not acknowledge coverage may be stopped by an unreasonable delay in disclaiming coverage or in giving notice of the possibility of such a disclaimer. Now, this is actually really interesting and unique to New Jersey. This case, the Barrett case, was 20 months the carrier did not give a coverage position. For 20 months, they did not say the claim was denied. And obviously, in those 20 months, the property owner did some work, and ultimately, after 20 months, the carrier denies the loss. And the property owner comes back and says, wait a second, 20 months, and you never even warned me that this loss might not be covered. What the heck are you doing? So ultimately, they came back and said that alone, that delay of 20 months, is enough to acknowledge that they could be stopped from using that defense of a denial. Now, again, there's a big difference in 20 months versus 2 months. So I'm not saying, hey, you don't get a response for 2 months, the carrier is going to be stopped. But there is a line there. I don't know where that line ultimately falls. 20 months is enough. 2 months probably isn't enough. But we can work on that. And if you guys have questions in the field as that happens, let me know. That was New Jersey. Virginia. Under the law of Virginia, the coverage of an insurance contract may not be extended by estoppel or implied waiver to include risks expressly excluded. Now that sounds almost exactly opposite of our New Jersey law. It says that they can ultimately be changed. However, lovely law and great writing from some judges, this is a general rule. There are exceptions. There are exceptions to this general rule that they can't get out of it. And ultimately, it comes down to the same thing. They have to have conduct that ultimately causes these homeowners to believe that there is coverage. And if you can get that, then you're going to have enough to make an argument for estoppel. One of the things I want to stress as we're going through this is not a guarantee. There is never a guarantee in the legal world. So just because the carrier did say something, just because the homeowner got a contractor, doesn't necessarily mean that the court will absolutely will agree with you on the estoppel claim. What I'm telling you is that based off of the law, they should. Doesn't mean they will. Maryland, a party asserting the benefit of an estoppel must have been misled to his injury and have changed his position for the worse, having believed and relied on the representations of the party sought to be estopped. Sound familiar? It's just a different way of saying the same thing I've been saying over and over. If I haven't made it clear, you've got to have a reliance and damages as a result of that reliance. It's not good enough for them just to say it. It's nearly impossible to win a case on waiver alone against an insurance company. Just to say, oh, they said one thing, they did another, they've thus waived it. It's never going to happen. Don't try and win that fight. So let's get into the other side of this before we get into the questions. Now, that's all of the estoppel stuff, and we've got some great questions that'll pan this out. We had a ton of responses, so I just want to get this background stuff finished, and we'll get into it. Proofs of loss. The biggest question that comes up is, when to use proofs of loss, how to use them to our benefit. Well, the big benefit is going to be in using what's known as a hostile proof of loss. Hostile proofs of loss. A proof submitted before the loss has been fully adjusted by the insurer or before agreement on the amount of property damage or business interruption loss. In essence, You send this over when you are satisfied with what the loss, what you've presented for the loss, but the carrier is dragging their feet and not giving you a coverage position. When you have that situation, you can send a proof of loss and use it to your advantage. I found some great text. These words are not mine. They were from an article online. But in essence, these hostile proofs of loss can scare insurance companies because it forces them to do certain things. And insurance companies hate to be forced to do certain things on a timeline. What kind of things are we talking about? Coverage decisions. Taking a look at the Allstate policy. These are just examples of carrier policies that you can look at to see what it requires. Allstate's policy will require a coverage decision as to their options, is what the policy says, within, I think it's 60 days, but it might actually be 15. I'll have to double check that. It might actually require payment within 60 days of the proof of loss if it's a covered loss. So they've got to give you not only the decision, but would actually have to be within those 60 days. These are a few carriers that have that. Limitations on carrier options to repair. Now, this comes up very rarely, but it does happen, where a carrier wants to do the work themselves, let's say through remediation. They might send out their own company. They don't do this nearly as much anymore. They used to do it a lot before, send out a remediation company to do the work, but they've realized the risk that holds to them. Nevertheless, the policy eliminates the option for them to send out their own person after a proof of loss under some of these policies. Now, what does that mean? The Travelers Nationwide, and I think the Allstate policy has this as well, says something along the lines of you, within 15 days or 60 days of the proof of loss, we have the option to send out someone to do the repairs for like, kind, and quality. The Allstate policy is the best example of this because what Allstate's policy says, and this is so rarely argued, this is a real secret, so hope you're paying attention. The Allstate policy says Allstate has two options when it comes to damage to a property. Either they can repair the damage themselves with their own contractors, repair it with like, kind, and quality, option one, or two, pay to replace the damaged property. Now, did you catch that? I'm curious if you did, because if you haven't been to one of my talks about this before, you might have missed it. Option one, they can pay to repair the damaged property. Option two, they have to pay to replace the damaged property. So one is they pay someone themselves to repair it. Option two, they pay someone to replace it. Well, you might sound like, well, what's the difference there? Let's say you've got hardwood floor damage. And a repair to the hardwood floor that would be perfectly reasonable would be to sand and refinish it. You've now repaired that hardwood floor. Conversely, if they don't have their own person do it, if Allstate elects to not have their own contractor do the work, the only option under the Allstate policy is to replace that hardwood floor. The word replace is the only one used in that provision of the policy, makes a big difference. So that was a nice little sidetrack, but an important thing for you guys to know. With all of these though, you need to be aware of the word and. A lot of these policies have sending a proof of loss and something else to trigger an event. Make sure you're reading the policy. It might say when within 60 days of sending a proof of loss and our agreement as to the amount of loss. If that and is in there, it changes your tactics. So make sure you're reviewing the policy of that. All right, we're going to get into the questions. There was a ton of questions. I really appreciate you guys doing this. If you've got more based off of just that background or as we go through these questions, let me know. I tried to address every question. I did address every question that actually relates to this topic. At the end, if we've got a little bit of additional time, if this hasn't taken that long, I actually tried to address some of the questions that weren't related to this topic at all, but I still think are important and it might give you guys some insight. So feel free to stick around to the end regarding that. First question, could actions of an insurer create an estoppel precluding the insurer from utilizing the lawsuit filing limitations as a defense to a claim where the time period had expired and suit was not filed or an extension obtained? Little convoluted here, but a great question nonetheless. In essence, if the carrier is taking conduct on doing things as part of the loss, and as a result of what they do, the property owner does not file suit. If that happens, what are the options? Well, in a lot of states, there's a pretty hard line on the statute. Pennsylvania is pretty much the hardest out there. There's other states like Pennsylvania where it's generally for property owners 1 year from the date of loss. the actual date of loss. And if you don't file within that 1 year, you've got quite an uphill battle. But it's a battle that we like to have. We have been successful on a number of claims to date, actually, and we're filing more and more of these, where the carrier does exactly this. Let's say the claim goes to appraisal. We've had carriers who have gone to appraisal and then denied the loss after appraisal, after the 1 year suit. They just didn't pay the appraisal award. That's absurd. And the courts agreed with us. The courts came back and said, no, you cannot use the statute of limitations defense when you make affirmative steps to go past that suit limitation under the guise that you will be providing coverage. This is not a slam dunk, guys. I can't stress enough. If you're able to file something, a writ, file a complaint and put it on hold status, whatever you might need to do, get it filed before the statute of limitations. But there are cases that we have been very successful on getting past this. So if they do something that extends it, give me a call, let me know, we'd be happy to discuss it. Can we record our conversations and walkthroughs with an adjuster to prove what they said? A fantastic question. This one also comes up a lot because one of the things is, well, how do we prove that they actually said what they said? Well, like I told you in the beginning of this, send the email. Shoot an email over to them real quickly when you get into the car, just saying, hey, just confirming what we said. That's going to be evidence to the fact that they did say it. If they don't respond back relatively quickly saying, no, that's not correct, or if they never respond back, we've got really good evidence that that's the case. Now, with that being said, some states allow you to record, others do not. I highly recommend you talk with a local attorney in your state. I want to make clear, I'm not licensed in every state in the United States. I'm not trying to provide you any legal advice to that, but I've looked it up just for you guys to have it. There are two-party consent states. Two-party consent states mean both sides need to agree that you are going to be recorded. If it is a two-party consent state, you cannot record a conversation if you don't have consent from both sides or they don't know that it's happening. Here is a list. Note there are a number of stars that I've placed on here for different states. It's because those states have somewhat odd rules, whether that be, oh, you can record if it's electronic, one-party consent, but you can't record in person without two-party consent. I think that was Illinois, but again, I don't practice in Illinois personally, so I don't really know. But you're going to want to check this out to find out if your state allows you to be doing that. If your state is not on this list, generally that means it is a one-party consent state, and that means you could record the conversation. Cannot stress enough, check with a local attorney for that question if you're more curious about it. If you are in a single-party consent state, then you can use that recording to prove what they said. My proofs of loss are always rejected or ignored, often with no reason other than it's too high. What can I do about this? So this one comes up a lot because you've sent over a proof of loss, but they just come back and say your proof of loss is rejected. Proofs, there's an interesting aspect when it comes to the law. The proofs can't really be rejected in that sense. The claim can be rejected and the payment can be rejected, but they can't actually reject the proof. Policy doesn't allow for that. Now, what they can do is say that we aren't in agreement with the proof of loss and they need to continue to adjust the loss. That's fine. The word reject, though, I always hate that word because it's not accurate as to what is really happening here. They're allowed to tell you that your proof is too high. They're allowed to tell you that your estimate is too high or that you haven't proven your damages. Look, that's just the nature of our industry. They're able to make those claims. But what you need to do is to get them in writing to explain why. Follow up with them. I cannot tell you the number of cases that I can win because there's a good writing campaign by the adjuster before it ever got to me. The hardest cases I have are where it's always, oh, I called the adjuster and I said this and they said that. Okay, prove it, right? If you can do it in writing and get them to follow up and say, well, hold on a second. The policy says that we provide a proof of loss. We've now provided it. You need to tell me now within those 60 days, not why you're rejecting it, why you're not paying this claim. In essence, why you're denying it. They are required to do that. If they're not taking that stance, then you need to put them on the spot and get them to explain it in person. In writing, not in person. Some policies state submit proof of loss after their request of same, and other policies state within 60 days of the date of loss. How pertinent is the 60-day time limit when our representation starts after the 60 days is already passed? So this question actually has two things that I think are really important for you to understand when you're adjusting losses. And the first is this difference between when the policy says a proof of loss can be requested versus when a proof of loss can simply be provided. Those are two different requirements. A number of the policies do say you have to provide the proof of loss within X days upon our request. So if they never request a proof of loss, you don't have to send a proof of loss. It's not in there. You can use the hostile proof, which we talked about a little bit, and we'll get into a little bit more, but you don't have to send that proof of loss if they don't request it. Number two is this aspect of timing. If the 60-day time limit when our representation starts is, if you're already getting there 60 days late or more, what can you do? Still get the proof out. The 60-day limit on normal homeowner policies is really a question of prejudice to the carrier. In most states, what the law is going to come down and say is, carrier, if you got it on day 61 or day 95, if you weren't prejudiced by that fact, you can't lift your arms up and say sorry. There is an incredibly important but on this. If it is a FEMA policy, you absolutely must get that proof of loss in the timeline. There is no ifs, ands, or buts about it. It is a hard line that the federal government gets to stand by. If you do not provide a proper proof of loss within the 60-day period to FEMA under that policy, it will be an absolute bar to coverage if the carrier chooses to take it. So if you are dealing with flood losses, cannot stress enough how important that deadline is, because it will stop them from coverage and the courts will allow them to do it. The other aspects of this really come down to when to use that hostile proof. So I'm going to jump back a little bit only because Mario's typing some of your questions in and I appreciate you guys having these questions. But with this first section, if they don't request the proof of loss, can you still send the hostile? And the answer is going to be yes to that. A hostile proof of loss can always be used to start some timers against them. Whether they want it or not, it's going to allow you to get a response. Building these claims, one of the hardest things you guys deal with is getting proper response times from the carriers. I've seen it firsthand on a ton of cases where the insurance company delays these things over and over. I mean, they've written books about it, delay, deny, defend. So they do it because they want the client to get frustrated, and they want them to be frustrated with you, if not with them. Because if you are out of the picture, then the insurance company can come by and pretty much do whatever they're going to want to do. So that delay in that timeline can be done and helped with the sending in these hostile proofs to start that timer against them. All right, moving on to the next one. Please discuss process/issues with proof of loss marked as final by carrier. What are our options? How do we handle? This one, my biggest problem with proof of loss is this word. I absolutely hate that word. That word should not exist in a proof of loss, in my opinion, and it doesn't have to. So the first thing I want you guys to take away from this, there is no such thing as a standard proof of loss. No policy comes with a proof of loss attached that says, hey, Joe Smith, this is the proof of loss you have to provide if you've got a loss. So your proof of loss is just as legitimate as their proof of loss, is just as legitimate as my proof of loss. It doesn't matter. It's just a proof of loss. So that word does not have to exist. Cross it out. Take it away. It doesn't need to be in there. Can I stress it enough? I hate that word. Whenever I see these proofs come in, what will happen most of the time is the carrier has sent over a proof, and the proof says, hey, final proof of loss, just fill this out because we need to do a payment on the claim. Sometimes it's a partial payment, sometimes it's there for what the carrier is calling their final payment, and you're going to have to sue for the rest. Whatever the case may be, if they send the proof, it probably uses that word in it. Cross it out. Write partial. You have absolute right to amend that proof of loss, and they cannot come back and say otherwise. So that is your option, is to just cross it out. Write your own proof of loss. If you guys don't have proofs of loss in your repertoire of documents, get one. Talk to an attorney about, hey, is this going to be good enough to comply? Some policies have certain requirements as to what the proof says. So make sure you have the ability to edit it as necessary, or try to create one that's going to comply with all of the policies. But long story short, you are not required to use that word final. You shouldn't use the word final. Keep it out of your proofs. If they try and stand by the fact that they have sent you a proof of loss that it has to be signed, that proof of loss has to be signed by them. Tell them to show you where it says that, because they won't be able to do it. There's no law out there that says it that I've ever seen, and certainly the policy doesn't say it. All right, next one. Oh, this one's a doozy. What practical use do proof of losses provide? They are largely rejected by insurers. Many times require information that the insurer already has knowledge of, can pose problems when going to appraisal, and aside from triggering some time elements, which are typically addressed via insurance regulations already, they tend to be archaic, and sometimes confusing document. Sorry, stumbling up there a little bit. The truth of the matter is, a lot of this is right. I don't remember whose comment this is, but you're not wrong. There are some risks with proofs of loss, but the time element can help you. And that really is what happens here. So there's a few things I want you guys to know. And the states are different on this, so again, make sure you consult local attorneys to discuss some of these, but these are generally true statements. Generally, if the carrier already has the information that would be contained in a proof of loss, then it won't be held against the client simply because they did not provide a proof of loss. Again, not always the case, not in every state, but generally that is going to be true. And the reason being is obviously clear. If the carrier already knows the information that they're asking for in the proof, why on God's green earth do I have to supply it again? And the courts have said, look, the carrier, there's no prejudice to you because they didn't supply this. So you're right. Sometimes doing this can only cause problems. I'm not telling you by any means to put a proof of loss on every claim. That is not the goal. The proof of loss can be handy, though, on very specific claims. And the time element is the key. Is if you want to push them beyond just a response, because that's most of the time what regulations will talk about. It talks about response time for questions and things like that. It doesn't talk about coverage decisions. It doesn't talk about payment timelines. So a lot of times you've got to use these proofs for that purpose. Not to mention, it helps to document your file. So one of the things I tell people all the time before you come to me, depending on what the issue is, if it's an issue of responsiveness or getting the answers to your questions appropriately, a lot of times the insurance departments will want to step in and help with those. The insurance departments hate insurance companies that try and delay the claims. I know that sounds crazy because they delay every claim, but it's actually one of the things that these insurance departments will be willing to step in on. So if you can show them in your documentation, I've provided a proof of loss, they had this time frame, I've sent follow-up letters, and they still haven't done it, it only bolsters your claim. But there are risks, and you guys should be aware of the risks of the proofs of loss. Number one, a lot of times there's going to be claims against you that you are acting as a representative agent of the insured. And that means your actions are the insured's actions. So if you put something in the proof of loss and have the insured sign it or present it to the carrier under the proof of loss, that could be something that could be held against the insured if it's not accurate. You want to make sure that you are accurate with these proofs of loss. Because if you do put something in there that isn't and they can ultimately prove otherwise, that could be problematic for everybody involved. So just make sure you're putting in these legitimate claims. Super curious whatever someone just typed because it's got my partner's laughing behind the screen a little bit. I really want to know what it says. I'm going to go back and check. So whoever it is, keep it up. So hopefully that makes sense. There are times when these are beneficial, and that's what we want to talk about. When a carrier agrees to an amount to be listed on a proof of loss, are they obligated to pay that amount, or is it still open for negotiation? Unfortunately, they're not obligated to pay. Short of them making a representation to you that says, hey, I do agree to pay this amount, put it on the proof and I'll get you paid. Now they've made that representation. That's still not going to be enough. What you're going to need is that ultimately that reliance, that damage to the insured, that they've done something, they've taken some step to go further with this. And if you can take that next step and show that reliance, you're going to be okay. But simply making the agreement itself won't do the trick. I do different proofs of loss on every coverage A through D, etc. Do you recommend the same? This is interesting, and I haven't actually seen a ton of this in the cases that I've handled, where in essence, just for those of you who might not quite understand how I wrote this question, rewrote the question, they do a proof of loss for coverage A, then they do a separate proof of loss for other structures, and then a separate proof of loss for contents, and then a separate proof of loss for loss of income. There's no harm in this. I don't know whether it's absolutely necessary, though. there's really nothing to suggest that this would be necessary for any particular reason. So whoever did write the comment, I'm actually a little curious, if you are on the chat, what benefits you've found by doing this? Because on the legal side of things, legally, it doesn't make a difference. You could put all of them in one. It has the same legal effect as if you do them separately. I guess there could be some questions of legitimacy to them. If they're questioning the legitimacy of one, they're still required to respond to the others, which, as I talk this out loud, I think could be a nice benefit. If they've got a requirement to respond to the proof of loss within 60 days, if you send 4 proofs, they've got to respond to all 4 separately. So it's not going to be good enough to just say, oh, if you put all of them in one proof, I disagree with the structure, the contents, but I'm okay with loss of business or loss of use on the proof, but sorry, they're all together, I'm not paying the proof. If you do it separately, they can make those separate distinctions, and that could actually have some value for you. So as I talk it out more and more, I kind of like this idea. If you've got an ability to do this, I'm actually going to say I'd recommend it. There's no harm to doing it, and it only could provide benefit because they have to respond separately. Should a standard proof of loss be sent even if the carrier ignores demands for a copy of the policy, which would list the requirements? So this is interesting. First, cannot stress enough, and I think that's why this came in quotes, and I kept them because I agree completely. There is no such thing as a standard proof of loss. However, I think what the question is getting at is if you've got a proof of loss, are you okay to send that, or should you send that even if you don't know what the requirements under the policy are? If you need to have that extra ammunition to put a timeline on them, yes, absolutely use the proof of loss, send it over as is. We generally have a pretty good sense in the industry as to what these proofs need. The policy numbers, the limits, the claimed amounts, date of loss, cause of loss, addresses, name of the policyholder, signature. Those things are going to be pretty much necessary in every proof of loss, so get it over to them. Again, it puts them on the timer and puts pressure on them to give you an actual response. That's why we use these proofs of loss. So absolutely can still send it over. We talked in the last video, if you want to go back and watch it, about what to do about getting the insurance policies if they're not sending it. So I'll leave that to a different video and not repeat myself. Does a proof of loss need to be notarized? Generally, no, unless the policy says otherwise. So notarization is one of those things that comes up a lot. People always talk about, oh, I need to, if I'm going to sign something, I need to make sure it gets notarized like a proof. Unless the policy says otherwise, there's no requirement that the proof of loss be notarized, just signed. You go and sign things every day. You sign check receipts or receipts for your credit card at stores. There's countless numbers of things, contracts with contractors, countless things that we sign as a contract that don't have to be notarized. Notarization is a specific requirement for specific items, and unless there is something in the policy or your local state law that says otherwise, there is no blanket requirement that proofs of loss are notarized. What are the do's and don'ts of hostile proofs of loss? This was an interesting one because I think it kind of has been touched on briefly. Absolute do's for your hostile proof of loss. Do provide it when the carrier is not being responsive, right? The whole point of these proofs of loss that we've been talking about is to provide that. The big reminder don'ts: don't put in information that you're not positive about. If you are not sure if there is coverage for it, don't put it in there. Don't put the numbers in there for those amounts. Definitely don't put the words final. You do not want to ever suggest that this is everything and all that the clients are asking for. I've lost cases simply because the court believed that word final actually meant something despite what we argued. So short of those two things, there's not too much else, just blanket do's and don'ts for what is going to come up on these. You want to be careful with these proofs of loss. You can, if the circumstances are right, not even put numbers in there. It doesn't have as much weight for obvious reasons when it comes to payment, but you can write things like to be determined just to start getting some documentation in the file and to start trigger some responses from the carrier. The most I would use these for, the most common thing I would use them for is if they're not being responsive to other documentations and requests, send this over because it will force force a response of some sort, and hopefully you start getting the claim moving again. If the insurance company fails to reject the proof of loss, is there a waiver or estoppel argument? Well, hopefully you can answer your question based off of everything else I've said, but just in case you've missed it, no. It is not enough simply that they haven't rejected it. There needs to be some type of reliance on it. So if it were me and they haven't responded to my proof, I send a letter that says, I haven't gotten a response to the proof. Is it fair to assume that that proof has been accepted? If I don't hear from you, I am going to assume that you have accepted the proof. That line is critical. And you can do this all the time. Lawyers use this trick constantly. If you don't respond, I'm going to assume your answer is X. It's a great way to force a response from them, because if they don't, you've actually got some legal basis to make an argument that they've accepted the agreement. So if you get that, even that's not enough until there is that reliance. So send out the email, follow up, make sure that they understand by not responding, you're accepting it as true, and then have the homeowner get their contractor lined up, get repairs going on this thing, and you've got some basis to say they've gotten estoppel. If that doesn't happen, then you're going to have some issues of actually proving that waiver and estoppel. Please inform the masses on how does a regular contractor or salesperson ask such policy or legal type questions without infringing on crossing the lines of UPL or UPPA. So UPL is the unauthorized practice of law. UPPA is unauthorized practice of public adjusting. For any contractors that are on this call, you always need to be careful based off of your state law that you aren't crossing the lines to acting as a public adjuster. You can't interpret insurance policies. You can't represent the insured and be their representative for the insured claim. You can present the roof if you're doing a roofing job and the carrier wants to inspect. You can go and say, hey, here's the roof, here's what I'm doing and why I'm doing it. You're perfectly fine to do that, but you're not allowed to go to the next step and argue coverage. So as long as you're not doing that and you're not crossing that line, you generally should be okay. When it comes to unauthorized practice of law, you cannot interpret law. I'm sorry, I know most of you like to read these cases, and some of you know more than half the attorneys that I work with at some of these defense firms for insurance companies. But the truth of the matter is, because you don't have that law degree, you can't ultimately practice law. So you can't interpret it. However, you can cite it. There's nothing wrong with you doing a copy and paste job and throwing that into one of your letters. That's an acceptable thing to do, so you've got no issues with it. What I would recommend to every contractor on this list, depending on your state laws, talk to an attorney about getting that license, and if you can get a license as a public adjuster and a contractor, what are your limitations? It is incredibly powerful to be a public adjuster and have the ability to argue some of these issues that you couldn't otherwise argue. So I would highly, highly recommend trying to get that public adjuster's license so that you can do that. Just be careful. There are very specific laws that vary very specifically for state as to what you can do as a public adjuster and as a contractor on the job. There's issues of when you sign them up, when you do the work, all of that kind of stuff. So do it, but really think about being a public adjuster. It's a good profession to be in. Is detrimental reliance and estoppel the same thing? Generally, yes. When these terms are used in the industry, they're being used in the exact same way. What's nice about detrimental reliance is it sounds a lot more like what you need than just by saying estoppel. Detrimental reliance is exactly what it sounds like. You've relied on somebody else's statement to your detriment. That's what estoppel is. You can use them interchangeably, it's perfectly fine. What if the carrier refuses to acknowledge any revision request? I'm assuming this is a revision to the proof of loss or a revision to the estimates. Again, this gets into forcing their hand further down the road. So if they're not revising their estimate, you can send in that additional proof of loss for the overages and force that response. I can't stress enough, if they're just not responding to something, that is something that's worthy of an insurance department complaint, and you can get them moving their hand that way. Worst comes to worst, you have to contact an attorney. Someone like me, I generally do those letters without charge, so I'll just send a letter off for you as a favor to the insurance company saying, hey, get into gear, you're not responding to this, otherwise I'm going to have to really get involved, and that'll help do the trick sometimes. If you ever need one of those letters for anything involving these claims, feel free to let me know. Happy to help. If a company sends out the mitigation company, then denies the loss, they will pay for what was torn out, but nothing more. Are the rest of the damages still covered? So this fight comes up a lot. And I actually make the argument constantly that yes, it is still argued. I will go to my grave arguing that if they do the tear out, then they're going to have to pay for the putback. Because the whole concept being they've accepted and they've stopped themselves from denying that aspect of the claim. But it doesn't just stop there. So as soon as they tear out cabinet 1, they've accepted they have to pay for the tear out. That means cabinet 1 is covered under the policy. They've accepted that coverage. So the coverage doesn't just end at the tear out. They've got to come back and put it back in as well. This is one of the huge issues that comes up, and it's one of the reasons carriers haven't been sending out as many mitigation companies, at least around here, because they recognize this issue. If they come in after the fact and do this, they're in trouble. We file litigation on this all of the time, and we've been generally successful on it because the courts tend to agree. If they're accepting coverage on in essence, the first half of the cabinet, the tear-out aspect, it's got to continue into the second half. For the hostile proof of loss, what if I'm brought in after the carrier underpaid the insured? Is this a good time to use a hostile proof of loss based on my numbers? Sure, absolutely. But again, I just want to make sure it's understood that these hostile proofs only are really necessary when you're not getting traction otherwise. I don't want to say they're a Hail Mary, they're not that crazy, but there are certainly 3 steps down the road before you want to use them. So you get involved, you present the claim, you send in your estimate, and you ask for a response. They're not responding to you. You follow up with a, hey, I never got a response to this. Can I get something in writing as to an explanation as to my estimate? They still don't get it. You hit them with a proof of loss. That hostile proof in that situation is exactly how you want to use it, because this makes a big difference. If they're just refusing your kind of representation because they've already adjusted the claim, it again puts them on notice of even more responsibilities on their part. Can you repeat the difference between the Allstate repair versus replace language? Sure. I had a feeling this might be a good catch for people. So under the payment provision under the Allstate policy, the Allstate has 2 options of payment when there is a loss. Option number 1, I think it says we can repair the property with like, kind, and quality. Number 2 is we will pay to replace the damaged or covered property. I forget what the terms, what it specifically says, but it's something like that. And the idea being, it says we can repair, meaning we Allstate can repair it, or we will pay to replace it. So they can repair it themselves, or they have to pay to replace it. That means repairs are no longer an option. So you've got, you can use this fight. It's easy on the wood floors. I've suggested, and I believe it's been successful, although I haven't seen the case, which makes me think it's been successful, is on a roof. If you've got a roof that's been damaged, the damaged portion of the property is the roof. I would argue, well, hold on, Allstate, you want to repair the roof? Sorry, can't do it unless you're doing it yourself. The only option under the policy is to replace the roof. Now, they're going to argue, well, no, I'm replacing the damaged shingles, and that's going to be the fight, but it's one that's at least worth having. So they can repair it themselves, or they have to replace the item. With Allstate, using a hostile proof of loss, and they don't send a repair person, they owe for a new replaced roof? Well, I apparently am psychic, had no idea that was going to be the next question. You now know my argument. If they're going to try and argue that they're replacing the damaged shingles, we're going to be arguing the roof. All right. Regarding 2-party states and 1-party states, is there a rule for phone conversations when people are in different states? Yes, great question. Whatever the more restrictive state is. So, perfect example, Pennsylvania is a 2-party consent state. If you are in Pennsylvania, and if you're in Pennsylvania and your listener is in New Jersey, you're going to fall under the more restrictive state for Pennsylvania for the rules for the recording. If you're reversed, if you're in New Jersey and they're in PA, same deal, the more restrictive state. So you want to be very careful with that. Know where they're going to be. A lot of times these, if you get a desk adjuster, they might be in a state you didn't even realize they are. They could be out in Illinois for State Farm, who knows what. Make sure you know that before you plan on using the recording. It is enough, by the way, this is a clarification, it is enough to say it's against the law to even make the recording. Now, I don't know how they know if you've made the recording if you don't try to use it for something, but be careful. It's not just enough. You can't use the defense of, oh, well, I recorded it just for myself. I was never going to use it anywhere. That's not enough of a defense, so be careful with that. When you've got these two states, you can do a few things. You can ask them, hey, I'm going to record this. Do you have a problem with it? You can do an automated type of messaging like you hear all the time on these things, before someone calls. This call is being recorded for quality and assurance purposes. Total BS, but it does the job. Courts say it's good enough. So you've got some options there. What if you record without permission and then the claim goes to litigation? Can you provide that? I really think I'm starting to read people's minds here, guys. I don't know what's happening. Can you provide the recording to opposing counsel during discovery and get it admitted that way? No. Unless it is a single party state, you cannot do this. Can't stress enough. If it is a two-party state, do not record that conversation without the authorization of the other side. Even if it doesn't matter if I get it in litigation. Candidly, if you've done that in a two-party state, I don't want to see it in litigation. So definitely don't want to provide that to counsel. If it is a single-party state, absolutely. Send it over. We can use it all day long. Those statements are coming in. Those statements come in anyway. Hearsay, when it's a party opponent, i.e. a representative of the carrier, those statements are allowed to be admitted. So I can talk all day long about what Allstate told you in the field. Having that recording would actually be nice as long as it's a single party state. So, oh wait, did you do that? Okay. Side note, if the policy says it must be a sworn proof of loss, it must be notarized. The FEMA flood policy absolutely requires the proof of loss to be notarized. That's right. So it's right in part. So FEMA does require notarization on their proofs. But again, that goes to specific FEMA regulations. FEMA proof, in the world of FEMA proofs, is a completely different ballgame than the insurance company's proofs of loss. So absolutely agree. The sworn aspect is it's actually enough if it simply states that it is a sworn statement. Notarization does not automatically equal sworn under most of the laws. So you could be fine as if there's a preamble on there that says, I swear to the truth and veracity of the blah, blah, blah. You can do that. We do it all the time with affidavits for the court. So we have to sign an affidavit, have the client sign an affidavit. You have a little sworn thing at the top. That's going to be good enough. So just notary does not automatically equal sworn. Just something to keep in mind. If a carrier or CAT adjuster goes absent and has not replied to several phone calls / emails, is that a good situation to use a proof of loss? Absolutely. So this is what we're getting at, right? This is one of those documents that forces their hand both within their own policy and within a lot of state statutes. So using that proof of loss, this is exactly where you want to be using it because you want to force that response from the carrier. One good thing to know is if there are CAT adjusters on these losses, you can often send it to the carriers directly, and will also count as notice to them because the CAT adjusters, if they're assigned from a third party or something like that, while they are acting as the representative, it gives you a little extra ammunition to use if you've also sent it to the carrier themselves. What should I do if the policy says, we will supply you with the necessary forms, but they won't give you the form? Should I just file my own proof of loss? Absolutely. So the policies are super vague when they talk about these forms. Most of the time, they're not defining what form they're talking about. So you're going to get away with sending in your own proof here. Remember, any of those ambiguities always are read in favor of the insured. So we argue all the time that the forms that they're talking about are forms for the insurance application, payments, things like that, not when it comes to the proof of loss, because the proof of loss section does not identify itself as one of those forms. Homeowner has a water loss, calls carrier. Carrier states, homeowner has duty to prevent further damage. Homeowner has contractor do demo. Carrier comes out and then denies the claim based on seepage exclusion. Would this be detrimental reliance? No, not yet. So unless it's only detrimental reliance, if the carrier says you're covered for it, now go do your remediation. So just having it within the, just having it said that the homeowner has a duty to prevent further damage, that alone is not going to do it. There's a really important thing I want to point out since this provision came up. 99% of policies say that the insurance company has an opportunity or has a requirement within the policy that says you have a duty to protect your property from further damage. And you have a duty to show us the damaged property whenever it's reasonably requested. And they use that word reasonably in most of these policies. And that distinction is something that these carriers try to fight all the time. The problem is there's absolutely nothing in the policy that says you have to show us the property before you remediate. And this comes up all the time, and we fight it all the time, and we're successful because the policy simply states you have to do the remediation and document your repairs, the repair expenses. That's it. It doesn't say take photographs first. It doesn't say take a video first. It doesn't say make sure we see it first. If the carrier hasn't made the request to see the property yet, you generally have a solid argument to stand on to say that the work was done pursuant to the policy provisions. I've documented the expenses. Here you go. Now let's go inspect the loss. With that being said, while you can use that argument, take photos first. Please, for the love of God, take photos first. There is nothing in the policy that says you have to, but it certainly is the better practice. If you have photographs to document the loss, the carrier can't come back and say, we didn't get a chance to see it. Sure you did, here it is. I didn't have to do this, but I did it because I wanted to be helpful for you. So take those photographs before you have the remediation done. If you work with a remediation company that you're sending out first, make sure they know to take the photographs first. Remediation companies need to be in the business of documenting the loss before, during, and after remediation. If they're going to tear it out for being wet, I better have a picture of that water meter on that wall showing that it's wet first, right? That's the kind of stuff that wins these cases day in and day out. No. Is there a timeline for Allstate's repair or replace before you demand they replace it? No. So the policy under the Allstate policy, there is no provision that gives a timeline, as far as I can tell off the top of my head, that says they have to do it within X days. However, the proof of loss provision says that they've got to give you their options within those, I think it's 60 days. There's weird memory says it might be 15, but I think it's 60 days. And under that Allstate policy that says we have to tell you the options that we're going to employ within those 60 days, will trigger their timeline to do this. So if they don't have someone come out to do the repair within those 60 days, you now have a very solid argument to say, sorry, Allstate, you didn't tell me within those 60 days that you were going to send someone out to do the repair, so now I'm getting my replacement cost. All right? Great thing to be using against them. Oh, I forgot the holds on. Sorry. So Mario was updating another one of the questions. With Allstate, if you guys aren't sure where this language is, it's under the loss payment provision, so how we pay for a loss section. It can be found under there. If you don't have a copy of the Allstate policies, let me know. We try and keep an updated bank of the major carriers. So if you need something, if you want to take a look at some form language, we can do it that way. The other nice thing is if you understand the form numbers, which most of you I think would probably do, HO 0106 5238, you can generally do a search for those numbers online and get a copy of the policy that way. Sorry we didn't get to the off-topic questions due to time. Oh, didn't realize we're at the hour. reading this out loud. So we have hit the hour. I don't want to keep you guys beyond. I see a lot of you are still on this. If you want to hop off, now's going to be the time. I'm still going to hit the jump through these real quick, even though Mario threw these in there and we want to go eat. So I do want to do it, but get this important information, guys. Phone number for the office and the WDB legal. We are officially done the proofs of loss and estoppel stuff. I really hope you guys enjoyed this. And if you guys have any questions, comments, concerns, next topic ideas, let me know. I'm always up for that because we're always looking to see what's actually helping in the field. To get to a few of the off-topic things. When the date of loss is different from the date of discovery, and you are now past the statute of limitations because of the date of discovery, what can you do? This one's a great question and something that we've recently had to fight over in a few different cases. Now, first and foremost, there are those situations where we're past the statute date because of things that the carrier has done, going to appraisal and then refusing to do it. Or simply, I have a case that's going right now where the carrier denied the claim simply because they hit the suit limitation provision. It was nuts. I've never seen anything like it before. The denial letter says, we're denying your claim because we're now past the opportunity that you can sue us. What? Ludicrous stuff. So in those situations, you still got to fight. In other ones, there are states, New Jersey being one of them, where if you discover the date of discovery is actually the date that matters. There's really good law in New Jersey, and if you need this, let me know. That says the date of loss, if you will, is the date of discovery. And you will actually have to go to your carrier at that time for that loss. So the situation that came up, we had a loss that we had clear knowing evidence that it actually happened like 4 years prior. The claim was put in with the carrier from 4 years prior based off of the date of discovery. And then we were fighting over it with that carrier. Ultimately, it's discovered that what mattered was the carrier at the time of the loss, or the time of the discovery, I'm sorry. So the date of discovery, New Jersey had this nice rule that in essence, the time that it's undiscovered isn't counted against you, so you can fight it that way. I would highly recommend that you talk to an attorney in your local state to determine whether or not you've got any similar type rule. If you can't find that attorney, let me know. I'll find what I can for you, either as an answer or a connection. Insurance company requiring 3 trades or more. Overhead and profit, replacement claims due to a windstorm. Can appraisal move forward against FEMA after property has been sold? This one was a bit of a jumble, but there's a few interesting things that I wanted to get out of this. First of all, the 3 trades rule is an industry standard, not necessarily something that is written into a policy or written into a case law. So while I've even personally argued 3 trades under some of the case law up here, like the Gilderman case, which was against State Farm regarding overhead and profit, the reality is that's not written into the code or law anywhere. Now carriers are starting to say the complexity of the job. The complexity of the job is just some ambiguous phrase that they like to use because they sometimes don't want to pay overhead and profit, and sometimes they're okay with it. So long story short, you can't necessarily rely on 3 trades unless you get them to agree on that. So appraisal against FEMA after it's been sold. There is absolutely no restriction in the policy for FEMA or any other policy that says appraisal has to occur before the property is sold. So hopefully in that situation, you've already got incredibly good documentation that will allow the appraisers to do their job, but simply the fact that the property has been sold is not going to be enough. I've had cases go to appraisal after it's been sold, and one of the items that you can look at, depending on your state and whether or not they've got the broad evidence rule, is loss in value of the property. So one of the measures of damage can be that loss of value in the property because it was sold and because the repairs weren't done from the loss. So if you've got that broad evidence rule, something that you guys should be considering for when you're presenting these claims generally, let alone with appraisal. There is also really important, guys, anyone that's still on this call, there is no restriction on the timeline for appraisal. I want to repeat that because it bears repeating. There is absolutely no restriction within the policy for your time frame for appraisal. That means if you are after your statute of limitations date, you can still go to appraisal. It is another common way that we've been fighting these cases. We've had carriers who have refused to go to appraisal because they can't be sued anymore. That's ludicrous. This is still a contract. They still have requirements. They cannot and will not be okay saying that they're not going to appraisal because it's past the statute of limitations. So if you are past one of your great outs of saying, I can't go to litigation, at least let me send this thing to appraisal. If you missed my appraisal talk, that's still on our Facebook page. I'd highly recommend going back to that because it does talk about what can be appraised in different states, whether it be appraising the scope of the claim or being stuck with the scope according to the carrier. All right, so, can I move? Is this the last slide? Nope. Oh, there we go. After making a payment on coverage A, can the carrier then require a recorded statement on coverage C if it was all part of the initial claim? And the follow-up is the carrier allowed additional investigation after issuing payment? The answer to both of these questions is yes. They are allowed to continue to investigate the claim as long as they need to, in essence, to determine what the proper payments are. Simply because they've paid for one thing doesn't mean that they're all of a sudden the clients are off the hook to do their responsibilities under the policy otherwise. An important thing to note, and one of the reasons I wanted this question to come up, most policies do not have a requirement to sit for a recorded statement. It says you have to cooperate with the investigation, and if they ask for an EUO, an examination under oath, you are required to do it, but not a recorded statement. If you really want to be a stickler, not that I recommend this, you could say, I won't sit for a recorded statement, make it an EUO, and I'm fine. If your only goal is to piss them off and make them spend money on an attorney, go ahead, but it probably isn't going to be to your benefit, because once an attorney gets involved, we get a lot more stingy. Well, not we, but defense attorneys get a lot more stingy with coverage. So just an interesting thing to have. However, when it comes to this additional investigation, I just recently had a case up here that went to appraisal. And during appraisal, the carrier tried to get a examination under oath. And we fought that. And we came back and said, hold on a second. You've already accepted coverage. The only question in dispute is the amount to be paid for this claim. You've got all the information. It's in the hands of the appraisers. You're out of this, carrier. Sorry, you can't do anything anymore. It's with them. You can't take this. And the reason we were able to do that is because the policy only says you have to do it whenever it's reasonably requested. And we argued there can't fathomably be a reasonable request, because you no longer have the power over this claim. It's been sent to appraisal. So you have that type of situation. That's something that you can use against them to say, look, there's no reasonable basis to do what you're doing, so we're not going to do it. I want to caution everybody. Taking a stance of I'm not going to give you something, or I'm not going to do something because I think it's unreasonable, is a tough stance to make. So unless you are super sure, and I would highly recommend speaking with an attorney first about your stance, just give it to them. I mean, there's so many situations where I could see it working out differently for adjusters if they just played nice. I know that's annoying because it always feels like we've got to be the bigger person. The truth is, we do. On our side of the game, we have to be the bigger person. And the reason being is we are at a disadvantage to them because of money. We're at a disadvantage to them because they ultimately hold the decision power. They've got that power. So if we play nice, when we do have to fight these down the road, we will get way further with these claims. So sure, we can fight these things and you can push back sometimes, but the real question is it worth it? I'm not telling you just to roll over. Fighting the insurance company, I love it. I do it every day. But just know that there are times to play nice and times to push back. All right, so moving to the next one. Oh, almost got it. There we go. Allstate denied appraisal based on 60-day proof of loss after date of loss. Do you believe it is a viable strategy to wait the term and try the now you have to replace? I'm a little confused by this. Let me read it again. Allstate denied appraisal based on 60-day proof of loss after date of loss. So I'm taking that to mean they denied appraisal because you didn't provide the proof of loss 60 days within the 60-day period of their request. And do you believe it is a viable strategy to wait the term and try the now you have to replace? So interestingly enough, appraisal and the proofs of loss are two separate provisions within every policy. So unless there is something in the policy that says, and I don't think there is, unless there's something under the appraisal provision that says that one of the prerequisites is complying with the proof of loss provision, they can't deny. Most of these are doing that. Waiting the term period for the now doing the work, now they have to replace. I can be pretty sure to say they're never going to be the ones doing the work. I mean, I haven't seen it. Property short of remediation, but actual repairs, I've try to do that. Maybe it's different in different states that I don't practice in, but you're going to be okay going with this replacement and putting them on the spot. So you wait the time period, send your proof, wait your time period, and then go for the replace. In this situation, seems like it should be fine. Virginia, a date of discovery state? No. So Virginia bases it off of the actual date of loss. Have some extended suits. Their averages in their policies aren't always 1 year. So make sure you're checking your policies. Sometimes you can get 2 or 3 years in there. So just know that when you're going into it, check your policy. And those, by the way, the averages are both homeowners and business losses. Does submitting a proof of loss in the 11th hour toll the claim? What about appraisal? Does that toll the claim as well? So this is going to be dependent on state. Pennsylvania, for example, nothing tolls the claim. There's nothing out there that will toll the claim. It doesn't happen. It will never be the case. Although we're actually going to recently file a case that we're trying to fight that, but nothing tolls it. New Jersey, as long as the claim is being investigated, it will toll during the investigation. So proofs of loss, appraisal, all of that tolls the claim. In something like Pennsylvania, going to appraisal, if they agree to go to appraisal and then they later deny the claim, while it doesn't toll it, we've got plenty of arguments on this. That's what we've been successful on, still fighting those claims. So make sure that you've got your ducks in a row. My absolute best advice, if you're at the 11th hour and about to pass your statute, call an attorney immediately. We can get things filed pretty quickly. So, let us know and we'll get something on the books so that this doesn't pass. You don't want a liability claim against you because, you didn't advise the client about the statute of limitations. Carriers state the insured should have started the repairs upon payment of ACV, even though there was no agreement to the cost. Ultimately, there was a $60K difference. Carriers suggesting the difference could be worked out while the repairs are going. So this is super interesting. I've got this exact case going right now. Ours is a little bit larger. They paid out $500,000, and our estimates are like 1.2 million. But they make the same exact claim of you can start ACV. Here's what I tell them every time. What contractor in their right mind is going to start a job that they don't know what the end work that is necessary to be done and what the end cost is going to be? No contractor is going to do that. So there is no way to start a job simply because they've gotten some money so far. They could do the remediation work, absolutely should get done. You don't want things getting worse. Short of doing that, doing any other repairs to the property without knowing a full scope is irresponsible, in my opinion. In my case, and the reason this is such a great case to fight it, the carrier did an inspection in just last October and November of 2020, and made an additional payment. That was 3 years after the loss. If my clients had started doing repairs, they would have never been able to see it, never accepted that payment. So you're prejudicing the claim if you do the repairs and it's not fully scoped and fully agreed to yet. So with all of that, unless the carrier agrees to the scope, I would not be doing the work because of that exact issue. Happy to talk, whoever that was, we can talk more in depth about this. Be happy to. All right, guys, those are all the questions. I cannot thank you enough for your time today. Hopefully you learned a lot. Hopefully you got something out of this. If you have any questions, again, my information is over there. You should have it by now. Let me know. But otherwise, everybody have a great weekend. Enjoy the nice